everybody, Mark Stiles down here at Studio B at 892 with my friend Thomas McCoy. You can find him on Facebook, Studio B at 892, or email tom@yourstudiob.com. Folks, last week we talked about being a landlord, buying investment property and being a landlord, and we tried to demystify some of the things you want to do, but no matter what, the relationships will end. So what are we talking about today, folks? We're talking about terminating the relationship with your tenant or customer if you watched last week's video. Now, folks, I want to remind you we are talking about Massachusetts law here. When we're talking about landlord-tenant law, we're talking about Massachusetts law. It's very different in every state. Some states, I'm told, you could send them a letter 7 days later, take all of their property and put it on the sidewalk. Now, that's not the case in Massachusetts. So let's start with a situation where we end the relationship amicably. So you do all of what you need to do in the beginning. Your customer pays you monthly, and they're moving on. They're buying a house, they're moving out of state, they're renting another property, and it ends amicably. What should you do? Well, step one, you want to meet with them. You want to meet with them at the property and walk through the property and see if there's any damage. Hopefully, if the relationship's gone really well, it'll be a nice visit to say goodbye and congratulate them on their next move. Walking through the property, oftentimes they will point out things that went wrong during their tenancy. They may point out what looks to be a problem. Now, if the relationship went really well, they paid on time, do the right thing, pat them on the back, congratulate them, and just say, you know what, it's normal wear and tear. It's part of doing business, the cost of doing business. Now, you have 30 days to give them their security deposit check back. But if it went well, have it ready, give it to them right there, and then you don't have to worry about any time restraints. However, if there are repairs that need to be done, agree to what they were. As you're there with them, agree, this is what needs to be done, and then we'll take the steps that we'll talk about in a minute. But bottom line, you want to symbolize the terminating of the relationship by taking the keys from them. You want them to hand you the keys. They have vacated the property. They have released themselves from the agreement with you. But you say, Mark, what happens if they don't show up to that last meeting? Things went well, but they're busy, they moved, and they couldn't get an appointment on the schedule to meet with me. Well, you need to go through it, take pictures, time-stamped pictures. If there's damage, you have to go through a certain process. And you want to follow that protocol very closely. You have 30 days to notify them of the damage, along with receipts for the cost associated with that. And you have to notify them and prove that you notified them. So that's certified mail. So you can give them a check for the difference, showing them what money you spent. Again, I implore you, if it's ticky-tack stuff, don't risk it, because this is a highly litigated issue. And most importantly, if you did not hold the money properly, like we talked about in the last video, do not try to withhold the money, because if they challenge you on it in the court of law, it can be devastating. They can get treble damages. What does that mean for you Latin fans? Triple the damages. So your security deposit's $1,500. They can get $4,500 plus attorney's fees. So if you did not hold that money properly in escrow, do not try to withhold that money from them. Remember from last video, it's their money. Those are two scenarios where the tenant voluntarily moved. What happens if they don't? What happens if they don't pay you rent? Well, the unfortunate situation is you would have to evict them. Now, the process in Massachusetts is challenging. It's very time-specific and notice-specific. So we don't recommend evicting someone without an attorney, but you can. The court will allow you with certain exceptions. If you own your investment property in a corporation or LLC, then you're not actually representing yourself. You're representing a corporation. So the court will require that you get an attorney. Okay, so let's assume you're going forward with an eviction of a person who's not paying you rent. So what do? First thing you do is you serve them with a notice to quit. What is a notice to quit? In essence, you're sending them a notice that says you've breached our agreement and I'm terminating our relationship. You have 14 days, 14-day notice to quit for failure to pay rent. Again, Massachusetts. And pack up your stuff and move out in 14 days. So you say, Mark, isn't that like the other states? After 14 days, just put their stuff on the street? Well, it's not that easy in Massachusetts. So what you do, after the 14 days expire, if they have not moved out, you have to go to the next process. And that's serving them notice to be heard in court. And that's called a summons and complaint. Now, both of these notices, we recommend having served by a sheriff or constable in your area. The summons and complaint, again, is the notice for the person to be heard in court. So depending on where you are in Massachusetts, the court will have a certain date where they hear these hearings on Mondays, Thursdays, maybe sometimes Wednesdays, and you have what's called an entry date. So you serve them prior to the entry date, usually 1 week in advance of that, and then after that, they have time to answer the complaint, and then after that, there's a hearing date. So you have to know these dates. You have to know these dates in order to fill out the complaint properly. This is where a lot of people make a mistake, and the courts are not very forgiving. This is where the reputation that Massachusetts is very tenant-friendly comes in, because it's complicated, it's time-sensitive, and it's very specific. So that didn't do it either. The tenant didn't move out, and there's a hearing date set, and you're going to go to court. What should you do? Well, the court would like you to mediate it, and they have court-appointed mediators on staff ready to do that. So when your court hearing is called with your tenant, if your tenant is there, we recommend that you mediate the case, because that's what they want you to do. And the mediator is exactly that. They mediate the matter. They are not on the tenant side. As much as the reputation out there is, the mediator is in the middle. They very likely will indicate what a judge would typically do in the certain circumstances. So listen to them. But if you don't like what the mediator has suggested, you can go in front of the judge and have a hearing. Now, depending on the judge, the hearing could be very formal or very informal. If it's really informal, the judge will simply ask you to tell your story and have the tenant tell their story, similar to People's Court or Judge Judy. But if they are a judge that wants a formal hearing, you would have to follow the rules of evidence. That might be very complicated for you and might affect your outcome. Folks, I hope this content was helpful for you. I hope that you do decide to buy investment property. And if you do, we're here. We're here to help. 781-319-1900. All of our attorneys on staff are very familiar with landlord, tenant, and real estate practice. Folks, if you did enjoy it, please share with everyone and anyone, and please subscribe to our YouTube channel. Thank you and be well.